My name is Dr. Brown, for those of you who don't know me or haven't heard from me. Well, if you haven't, you're going to hear from me for the next couple of minutes, okay? Today, I'm going to be talking to you specifically about the rule of law as we apply it throughout our entire legal research process, okay? So far, you've already heard specifically what the facts are of our problem, the legal issue. Now, we have the rule. What is the rule of law? What the rule of law is, it allows us to determine what the legal issue is that's raised by the facts of our client's problem. We have to know that because the law will put us in the correct area. That's what we get paid the big bucks for. Okay? Now, how do we identify the rule of law? 3 very simple steps. First, we must locate the general law. Do you know what the general law is? You don't? The general law is the statute. All right? Statute which is made up by a legislative body. When we're talking about statute, we're talking about the actual law in the book. Not the statute that's in New York. That's the Statue of Liberty, okay? Now, our next step is how do we locate the law? But Dr. Brown, you've already talked about the general law. This particular step specifically deals with the court opinion, which is the judge-made law, or the case law, because that allows us to interpret how our general law applies to the key facts of the issue. And number 3, we have to make sure that we update our research so that we make sure that we're actually using good law. Don't want bad law, okay? Let's go a little bit more specifically into part 1. How do we locate the general law? We have to ask ourselves, what type of law are we applying to our issue? Now, Dr. Parsons specifically mentioned previously that it's very important that we read the specific facts. We have to know exactly what is going on in our client's situation. All right, here we know so far that Ernie Baker got into an argument with his coworker, Jack Smith. Mr. Baker, very, very hot-headed, punched Jack. They got into a fight. Then Alex wanted to lend a helping hand. He got involved. He's a local postal worker, and he decided to go ahead and get postal on Ernie, okay? So now what we have to do, we have to look at what does our client want. The specific facts say that Ernie wants to sue Alex for his batteries. Doesn't say he wants to throw him in jail, although I'm sure down the road that's probably what he definitely wants to do, okay? So our issue is specifically, under Florida's tort law, does a civil battery occur when an individual kicks a random stranger several times without police powers or official authorization to do so? Our issue involves civil battery, not criminal battery. Do not confuse the two, okay? We must determine whether or not Florida has a statute that defines civil battery. Now, since Florida doesn't have a specific civil statute, we must go ahead and go on to part 2, which will allow us to locate exactly what the case law is. All right? Now, according so far to the case law, in which we have to locate the relevant law, the Florida Supreme Court specifically provides that a civil battery is the unprivileged, intentional, and harmful or offensive contact with the person of another. Let's break that down a little bit further, all right? Person, it's the body of another human being. Privilege, it is a special legal right, exemption, or immunity granted to a person or class of persons. In this particular case, an example would be that police officers have a privilege to use appropriate force to arrest alleged wrongdoers. And a lot of times, if the specific statute or case law does not define it, define a specific term, what you can do is look into words and phrases or Black's Law Dictionary, okay? Our next step, which is really, really important here, is we need to make sure that our law is still valid. How do we do that? We do that by updating our research. We have to make sure that our specific law has not been any of the following. It cannot be amended, it cannot be repealed, it cannot be revoked, it cannot be overruled, it cannot be modified, or otherwise changed in any particular shape, form whatsoever. If it does, then we can't use the law anymore. It's not good, all right? If the law is not changed, obviously, we can rely upon it in our legal analysis. So far, from looking at our particular law and conducting our legal research, we know that Florida's law of civil battery is still valid, so we can use it. Remember, our law again, before we go on to the next step of analysis, is a civil battery is the unprivileged, intentional, and harmful or offensive contact with the person of another. Thank you very much, and happy eye racking.